Good evening, everyone, and welcome to the Wednesday webinar with Property Law Alliance. As always, it's so good to have you with us, our viewers, and it's so good to have our experts with us. Cilna, Steyn, how are you doing?
Whoa, formal with
Name and
surname. Christopher Abrams, I am very good. Thank you. How are you doing?
I'm very well.
The only time
And
people
Mr.
say that to me is when they're angry with me. So
What do people call you Christopher Abrams when they're upset with you, Bruno? That's amazing.
well, considering I have 6 names, people do struggle to get them all in when they're upset with me.
What are they? Please tell us.
Sure. It's like privacy, protection of personal information. I'm not sure this.
Just give us the second one.
Bruno, Miguel, Pereira, Casales, Cerveira, Simao.
Wow.
You can even say that in public, and your personal information is well protected. I'm willing to share. I do have a middle name as well. It's amazing, though. I'm going to leave it at that. How are you, Christopher?
No, please let us know what that middle name is now.
Okay, it's amazing. It's amazing. You guys are allowed to hold this against me, but Pietronella, Cilna Pietronella Steyn. Yes, that is in fact the middle name.
So one on the one hand, it's very Afrikaans. On the other hand, it's like the most Portuguese, a mouthful of Portuguese.
Exactly. Well, Chris, you know what a secret on that name? My maiden name was Lichtelm. So I grew up with the name Cilna Pietronella Lichtelm. Yeah. That is about as that as you go. If anybody ever wondered about my hair color or my eyes, it's Cilna Pietronella Lichtelm.
So there was never any doubt with you, Cilna, it's Afrikaans. There was never any doubt with Bruno, it's Portuguese. And then you get Christopher Abrahams and I'm Indian. Like, how does that work? But guys, it's so good to have you with us. Bruno, how are you doing, man?
No, I'm good. How are you doing?
Good, man. I'm okay. But I want to get straight into the session because we have a jam-packed one. We've got some amazing questions for our viewers. And let's start it off. So the first question goes like this. My tenant has failed to pay rental for 2 months. I drafted the relevant breach notices, and upon failure to remedy the breach, I have cancelled the lease agreement. I've done so in writing. I want to sue my tenant for the outstanding rental and possible damages. My only concern is that he is not a South African citizen, and it appears to me that he has actually left South Africa. Can I go after him even if he is abroad? And if so, how do I go about doing this? And then the second part of this question is that the tenant's girlfriend or the lessee's girlfriend had co-signed on the lease. Can I also go after her for the outstanding values? Let's start with the first one. Bruno?
All right. So the difficulty, let's maybe start right at the beginning. We're assuming that the lease has been cancelled. Naturally, this guy has moved out of the property, so at least that's safe. So now you're looking at a monetary claim. So this would be a claim for outstanding rentals and damages incurred or damages to the property, whatever the case might be. Maybe he stayed on the property for a longer period of time, so that's also considered to be damages because at that moment it was his prolonged stay actually caused the owner certain damages. So there's a couple of claims that a person might have against tenants that breached the lease agreement, failed to pay, and vacated late or left the property in a bad condition. Now, the fact that the tenant is abroad causes major issues, right? Especially when it comes to rental amounts, because we do need to look at the practical application of this just to see whether it's actually worthwhile pursuing someone that's abroad. Now, the specific reason for this is you tend to find that the general market-related rentals, if you look at it on average, typically stay around like below the 10,000 rand a month mark. And I mean, depending on how long this person stayed on the property without paying rent, I mean, very seldom would a landlord let this exceed huge amounts where you're sitting in the hundreds of thousands. So you do need to ask yourself whether it's worth it, because it's not a cheap process, number one, because now you're actually having to bring further applications to court. Now, when somebody's abroad, one does need to look at the jurisdictions of the court, but in our specific instance, the argument is the cause of action arose in South Africa, arose within a particular magisterial or high court jurisdiction. So the courts here do have jurisdiction, so you can sue out these courts. So that's good news. You don't now need to go chase them somewhere else, or you don't need to found a jurisdiction in South Africa, but you now need to serve the summons on this individual. You're naturally going to struggle to find this individual. He's not in the country. You can't serve it by the normal process within South Africa. So you need to, for example, to apply for edictal citation, which is basically an order where the court allows a special form of service by using an overseas official to actually serve the papers. Now, you tend to find that this is actually quite popular when it comes to things like divorces, for instance, because in divorces, you don't have a choice. You need to get divorced. So you're quite desperate to issue the summons and make sure that you go abroad, you serve it, and then you can at least get a judgment by the court here that terminates the marriage. So that works even if the person abroad doesn't react or doesn't say anything. At least the marriage gets terminated and you get your end result. So here now we've achieved step one. We've gone to court, gotten a special order, served the summons overseas by using an official of one of the courts overseas. Now, possibly you obtain default judgment. The next step is now trying to collect the amounts of money. And this proves to be an absolute nightmare. So unless the guy left money in the bank accounts in South Africa, or he's got some form of property, movable property, or some sort of asset somewhere that you can attach and sell, you're now going to need to look at the relationships between the specific countries and the possibilities of actually converting or enforcing South African court orders abroad, which is not the easiest thing to do. So this is an uphill battle right from the beginning. And depending on the quantum, how much you're actually claiming, I typically find that it's very few cases it's worthwhile, because then the third issue that you need to now remember is the same issue you'd face in South Africa. Is there any money or assets to collect on? So you go through this effort, you now manage to say, great, I can enforce it overseas, but is there anything to enforce it against? Because if you're going to struggle sometimes to collect rent within South Africa, now can you imagine going through all of this just to find out that the guy doesn't have any money? So that's the long and short of trying to collect from a foreigner abroad. I suppose the second part of the question's a nice answer, where if there's a co-lessee, and typically if there's a co-lessee, the contract would make provision for them to be jointly and severally liable for all outstanding amounts. So if the co-lessee, where the person co-signed, the girlfriend's still in the country, typically speaking, you'd be able to sue the girlfriend for the full outstanding amount. You wouldn't have to follow her overseas. You'd be able to do an assessment on whether you'd be able to collect the figures or not. So that would probably be your best option.
Okay, thanks, Bruno. Thanks for that. Just want to ask one question though. There was a particular, I think it was like a Latin term or something that involves the service in another country. It sounded quite dirty. Please, can you repeat that word for us?
Edictal citation.
Sounds a lot cleaner now. Sorry. So I'm not sure if you wanna touch on this topic, or can we quickly move to the next one?
I am not. I'm waiting to stop blushing for the second. It was perfect.
Okay, good. Let's forget that I said that and move on to the next one. So the next question, and for Cilna, I want to open up a liquor store. In order to do so, I have to find the premises in order to rent, so that I can show the authorities that I have some form of right or title over this particular property. I think that's one of the prerequisites for getting a liquor license. I have heard that it can take anywhere up to 6 months for a liquor license to be granted. And even in so, it's just as well, it could be rejected. Now, my problem is that I'm going to have to enter into a lease agreement. I'm going to have to be bound for a certain period of time, and not knowing what the future may hold. So in this particular instance, what could I do in terms of contracting with my lessor, the landlord, that suits him, but also suits me?
It's a very good question. And I think there's actually quite a few potential options that the tenant would have. But it would depend on the relationship with the landlord and the landlord's ability to hold the property or not. So say, for instance, you're in a strip mall and there are pretty high turnaround of tenants and very quick placements. A landlord wouldn't easily go for the option of waiting 6 to 8 months to confirm whether he's going to have a liquor store there as a tenant. Because remember, from the landlord's perspective, a vacancy is bad, and currently all landlords are having pretty high vacancies, and it's sad. I mean, if you walk through any mall right now, especially in retail, not to mention commercial. But you don't randomly walk through office blocks for funsies. If you do, I'm sorry, I don't mean you're weird. I'm just saying it doesn't happen every day. But through malls, you can see what the vacancies are currently, obviously as a result of the unfortunate economic climate that we are currently in. But a landlord wouldn't want to fill a space with a tenant that can only start trading 6 or 8 months in advance. However, if there is a landlord that's pretty desperate for a tenant, the place is anyway filled with vacancies, the landlord can wait, then we have one option. The other option, and I'll get into that just now, the other option is a landlord that has a current stable tenant that will only vacate in around 6 to 8 months from now. That option is obviously the easiest question to answer. In that case, you can do a lease agreement, and the parties will specifically agree that prior to the tenant taking occupation, the property will be fit for the use, for the intended use. So in most cases, a landlord, and I advise against a landlord warranting that a property would be fit for the reason it is rent, simply because bylaws change or zoning change. Well, zoning doesn't just randomly change, but bylaws change. And if a landlord says it's perfect, you can have a tire shop here, and the bylaws change, and you can't, then the landlord is responsible for the tenant's damage. So I don't like the fact, and I wouldn't recommend that a landlord warrants that it would be fit for occupation, but the parties can, in a special condition, agree that prior to taking occupation, prior to the lease agreement commencing, or prior to the tenant receiving beneficial occupation, all of these are different things and different terms in terms of a lease agreement, then he will have a liquor license. If he doesn't have a liquor license by X date, the lease agreement will lapse. And that was the initial part of my answer. You can do one of two things, either a suspensive condition or a resolutive condition. But the difference between the two are very important. And for both the landlord and the tenant, it's very important that you get this right. I think tonight, we might have quite a few attorneys as viewers as well. So for the attorneys, please make sure you advise your clients in the right direction here, because a suspensive condition means there's an event or a thing that must happen. And if it doesn't happen by a set date, the contract lapses. It's like it never happened. It is void. It's not voidable. It's done. It's like it never happened. Meaning that neither one of the parties will have a claim against the other. So if you are acting on behalf of the landlord, you don't really want this suspensive condition, because if he doesn't get the liquor license, the tenant, the landlord loses his full damages claim for the time that he basically held the property for the tenant. On the other hand, for the tenant, a suspensive condition could be handy, because if he doesn't get his liquor license, the contract falls away and he's not obliged to pay anything. But at the same time, a suspensive condition like that in the agreement might be a problem for the purposes of getting a liquor license, because the purpose of having to show which property you go into, if there's a suspensive condition, until the suspensive condition is fulfilled for actual true technical purposes, you don't have a contract yet. So it's a little up in the air, and I don't think that would work. But if you have a resolutive condition, so that's a condition that says, on this particular event, this contract will come into play. So he's sort of hanging in the air, and as soon as this happens, bam, we have a contract. Just like that, your contract will do that, like bam. It's amazing. And I think what's important to know is if you draft that correctly, it could be a very handy clause and safeguard both landlord and tenant. So what that clause would look like is typically something in the line of the landlord and the tenant agrees that the tenant will do everything in his power to obtain a liquor license by no later than, call it whatever, pick a date. If this happens, then the contract will come into being. If not, you can build in damages claims, and you can build in a bit of a penalty or just a bit of a benefit for the landlord, because otherwise, if you don't have the other side of the resolutive condition to really just help the landlord out there, the chances of convincing a landlord to do that is low, but it's not a requirement for a suspensive condition. You can, usually it doesn't go with a penalty or something like that, but more holding over damages that the landlord will suffer because he doesn't have a tenant in place. So I think that would be the best way of doing it. I wouldn't recommend that the tenant does this by Google searching. I do recommend get to a specialist attorney to help you draft that contract for both the landlord and the tenant, because for the tenant, the risk is if you do it wrong, you're going to end up being stuck to the agreement, but you clearly see that. The other risk is if you try to reduce the term of the agreement, let's say you decide to then only do a 3-month agreement or 6-month agreement to safeguard yourself. What if the landlord then in that time decide to actually let the agreement terminate? Then you went through all this effort just for 3 months benefit. And for the landlord, obviously the same potential risk of damages is very high, but it can be, you can mitigate most of these kind of damages with a properly drafted contract, as long as both parties are willing to come to the table and really negotiate in good faith and really try to meet each other halfway. Then it's very, very doable.
Thanks, Cilna. Thanks for that information. Hopefully when they're at the negotiating table, they bring an extra couple of bottles of whiskey with them, and the lawyers can indulge.
Because we all know lawyers, lawyers run on whiskey. Well, and tea.
Okay, let's quickly run into the last question that we have for the evening. We have an apartment for sale in a complex. Our estate agent put up for sale signs outside the complex. Now, these for sale signs are not obscuring anyone's view as they drive in or out of the complex. Ours was the only sign outside the complex, and the body corporate took it upon themselves to remove this sign, this for sale sign. And they stated that they just don't want these kind of signs outside the complex. Now, the viewer is a bit confused here because they've said that doesn't the property outside the complex, fall part of municipal property? So does the body corporate actually have a right to, undertake this kind of action? I think let's start with Bruno, and then we'll go to Cilna. Oh, sorry. I think we'll start with Cilna and then go to Bruno. My mistake.
See, now everybody knows we sort of have a bit of a plan before the time.
No, this is because
really barely.
Ladies first, always.
Yes.
We drew straws, and these are the questions we got.
And we use a magic 8-ball for our answers. Okay. So the answer to this one, I'm going to start on the body corporate side of things. Bruno is our newfound expert in the field of understanding municipal bylaws in respect of advertising. He's a definite expert in the field, and I can attest to that. But
Nice.
body corporate side of things, the body corporate wouldn't, it doesn't just have rights that they don't have, either in terms of their management rules or that the body corporate agreed to in terms of the conduct rules and in terms of resolutions by the members of the body corporate. So typically, a body corporate can't just go about and remove stuff if it's not in terms of the management rules or the conduct rules. So management rules is all sorts of practical, how the body corporate should run, what's the number of members, things like that, PQs and stuff like that, the boring stuff. Conduct rules are the things that people fight about and end up at seesaws about, because that's, can you have 2 dogs and 1 cat? And if it's a dog, how small is a small dog? How big is a big dog? That is the conduct rule stuff that we're talking about. Conduct rules may theoretically deal with things like this, like signs, what you're allowed to do, what you're not allowed to do, what color you're allowed to paint and stuff like that. Conduct rules may deal with that and usually do. But property outside the property, the only time a body corporate or a similar sort of entity would have any say over that is if the body corporate forms part of, say, for instance, a homeowners association, and that happens quite often, where you have a few complexes, body corporate managed complexes within a homeowners association. And the homeowners association then basically, not override, please don't misunderstand me here, but I want to say sort of in a way override the municipal things, not in a way where the homeowners association can contradict the municipal bylaws, but they have a bit more control over their areas. For instance, what kind of boom gates can you use? Where can you put up a boom gate? Stuff like that, which is, if it's not in a homeowners association, the municipality would have full control over. Obviously, your homeowners association MOI, Memorandum of Incorporation, and their conduct rules must be approved by the municipality. So that's why I said, don't misunderstand me on they may override it, but they have consent to do that. In a case like that, the homeowners association's conduct rules might say you're not allowed to have advertising signs anywhere, and in that case, the body corporate of the homeowners association may remove it, but not a body corporate in any other way. I can't see that they would have the right to act on any land outside of the complex. However, if all the parties agreed that nobody is allowed to do anything on the sidewalks, even though it's not really their jurisdiction, but let's be fair, I have seen things happening in complexes that I just smile and say, yes, that makes sense in our law. So I have seen things like that, and in those cases you can, but in the majority of instances, I can't see that the body corporate's jurisdiction would stretch to outside the boundary walls of the complex. However, there's a lot of people that would love that, actually, to then just run the municipality as the body corporate, but unfortunately, that's not the law. But talking about municipalities, over to the bylaw experts on agent signs.
Nice. All right. So
I'm not going to stop.
So building on Cilna's point, though, anything outside the wall is typically considered to be municipal land. Now, this is something that we all know, but I think we've lost a level of respect for lack of better words, because the reality is half the time it's us as property owners or body corporates or HOAs that actually take care of that little piece of land outside your property. So it feels like yours. Anything that's being put there seems like an invasion of your space, which is typically why I also find that people struggle when it comes to advertising boards on streetlights outside your property, and you feeling that it's inappropriate to have that specific advert, or that sort of those sort of considerations behind it. Now, so now going back to that, the municipality does control that section of land. And the advertising certain brands or making certain things visible to the public, especially in the form of advertisements, is something that is controlled by the municipality. Why? This is because it's a revenue stream, right? And I actually dealt with this quite a few years ago when one of my clients had certain advertising ideas, but that required a certain branding to be placed on items outside people's houses. And I still remember the schlep of actually applying to the municipality, trying to get permits for each and every house to try and put up these adverts. And I mean, in the property investor sphere, it's the same sort of thing we experience all the time. People trying to source deals very often try to utilize existing spaces. And I mean, this doesn't only refer to spaces, it's anything that's visible to the public. So there's even restrictions on how a two-story building is supposed to be used for the sake of signage or any sort of advertisements. They also need to get permits for that. So it's not simply just about the land. It's actually about what's visible to the people on this side of the wall. So that's why typically you find with zoning, they've got restrictions or limitations on size of signage, because once obviously you pay the higher property rates, you're allowed to use this advertising space inside your property to display to the public. But a lot of the times you wouldn't be allowed to do that. And that's why there's a whole bunch of restrictions. So the long and short of it is each municipality is going to be governed by their own bylaws. So, I mean, we were just having a chat now and we saw that in KZN, you're not allowed to put up any signage unless you get a permit as an estate agent. In Joburg, it's slightly different. So estate agents in Joburg, their permission actually comes from the bylaw, because the bylaw mentions them specifically, saying estate agents are allowed to display signage, but it can only say, to sell or to let. It needs to be a certain size. It can only have a name, address, and phone number. So there's a whole bunch of restrictions, but the municipality does allow estate agents to place it on municipal on that specific municipal land. So this is now where it becomes interesting, because you've got the Joburg municipality saying it's okay provided you meet certain requirements. You've got a body corporate saying it's not okay because it's right outside our property and we don't like it to be there. And who has the stronger right? I suppose it's a bit of a gray area, but I mean, if we look at it strictly from what we've said, it is still part of the municipal land. The body corporate's rights shouldn't extend past that unless for some reason it's in the conduct rules and all the parties at some point find this binding on themselves. That creates a bit of a gray area, but strictly speaking, you shouldn't be able to stop an estate agent from putting up boards outside a property, provided that they meet those requirements that the bylaws prescribe.
Oh, thanks, Bruno. Thanks, Cilna. So if there's any estate agents watching this, I think there's also a loophole here. What you can do is print out a t-shirt, give it to me with all your details on it. I'll just go sleep on the grass like for at least 5 or 6 hours during the day, roll over, and you get free adverts, and you don't need to apply to the municipality at all.
and then Bruno, I get the instruction to evict the weird random squatter outside the body corporate's complex.
It's a win-win for everybody.
We'll evict you nicely, I promise.
Oh, thank you so much.
Can you just imagine?
Smile.
Can you just imagine the brand damage, though? So no, but so you're wearing a T-shirt with an estate agent's signage, and I've seen it before, like very, very classy brands and very classy T-shirts that they must have handed out at some event. But they land up on the street, and eventually, like, the people wearing them aren't exactly the people that you'd associate with that brand. So yeah, that's just asking for brand damage.
Guys, on that note, speaking about evictions, I'm going to evict both of you from this webinar right now because we have to go. But thank you so much, Bruno. Thank you so much, Cilna. As always, such a wealth of knowledge and such a pleasure to engage with you guys, as I'm sure our viewers feel as well. To our viewers, thank you so much for joining us. Please drop your questions in the comments below, or post them on the group, and we will adjust them as we go along and as the weeks progress. But thank you so much for joining us. Please tune in next week, Wednesday at 6 o'clock, and see you all then. Thank you, Bruno. Thank you, Cilna. Cheers.
Thank you,
Cheers.
Chris.
Thanks.
Bye-bye. Bye.